Welcome to TFE Talks, Navigating Wealth, Business, and Legacy, the podcast from Thomas Fisher and Edwards. Each episode, our attorneys bring you expert insight on estate planning, business strategy, and legacy building, breaking down complex topics into clear, actionable advice. Whether you're solidifying a strategy we've discussed or preparing for what's next, this podcast is your resource for thoughtful, practical planning. You ready? Let's dive in.
Hello and welcome to another edition of TFE Talks. My name is Jordan Goewey and I'm your host for today, joined once again by my good friend and colleague, David Thompson. David, good to have you again.
Hey, good to see you here, Jordan. Looking forward to another edition of TFE Talks.
So, David, we're talking about a very important topic today that we obviously get a lot of questions about as estate planning attorneys, and that is probate. And so I'm going to start with just the very high-level overarching question, which is, what is probate? Because I think just the word alone gets confusing because it gets used in so many different ways.
Yeah. So when I'm talking to clients, I break probate down as two concepts. From a strictly legal sense, the term probate means to admit one's will as valid. So, somebody passes away. There's a process by which in any state you will take their last will and testament to the probate court or the relevant court that has the jurisdiction in that state. And you will seek to admit that will and the court will determine that it's valid. That's the legal concept of probate. To most people, the term probate means kind of the secondary component, which is administering a decedent's assets. So for example, when somebody dies, you have a period of time where you've got to wind up their financial life, their things. And that's what probate has come to mean, at least in the concept out in the real world to most people, as it's the part of administering those person's asset, the decedent's assets, and then making sure that they're distributed to whoever who's entitled to those assets under the will or their estate plan.
And so, David, the person who's actually doing all this is typically the executor or the personal representative. And so can you talk about that role and why that role is important and why it's important to select a good person for that role?
Yeah. So personal representative is the term that's used in South Carolina. And most of this talk is focused in the context of South Carolina probate administration and probate. Personal representative is the term. Functionally, and this is the thing that is broader than just probate, everybody has an estate plan, right? Under South Carolina law, if you die without a will, there is a statutorily prescribed estate plan that the legislature has picked for everyone. In that list, there's also prescribed priority for individuals to serve as a decedent's personal representative. So if you die without a will, the legislature of South Carolina has picked who will serve in this role, and who has priority to serve in this role. For many clients, they may have, they want to name an individual. Often if they're married, it may be their spouse. But even in the event that they're not married or if they're a widow or whatever the situation may be, they generally want to pick maybe one of the children or some subset of individuals, maybe a friend or a brother or some other individual that maybe under the statutorily prescribed list would not have natural priority to serve. And picking that individual in your will allows you to overcome that, right? So if you have a valid will and you name someone, they're entitled to serve in the event that they would desire, if they're willing to. So that person is responsible with, marshaling the assets of the decedent, locating, protecting, preserving the assets that are probate, and then administering claims. And we'll talk a little bit more about the process here in a minute, administering claims and making sure that the people that are entitled to these assets receive them.
And so, David, maybe taking a step back for a moment, another thing that you hear about when you hear about probate is that it's something you need to avoid. You talk to your financial advisor, you talk to your attorney, and everyone says you need to avoid probate. You need to start thinking about probate avoidance. Why is probate something that a lot of people try to avoid, and what are you actually trying to avoid as part of that process?
So I think there's a couple facets to that question. So the first piece I would say is that in the state of South Carolina, we have a process called informal probate and administration. And in an informal proceeding, it can be pretty efficient. Probate doesn't have to be this, thing that's a big scary event or a thing that's a problem that is problematic. Now, The issue that I think a lot of advisors and other lawyers as well see with probate that is really like timeliness. I mean, there are timelines and procedures by which there's periods that you have to maybe want to wait, which can cause delays and, distributing the assets to individuals. But the main things that you can get by not being subject to the probate process are a combination of things. There's a probate fee that's charged by each probate court here in South Carolina. The highest fee, it's a progressive rate. It keeps going up as you're on the fee schedule. But for probate assets, the highest fee is 1/4%. So if you have $1 million of probate assets, the most fee, and this is an overstatement of a fee if it's the first million, would be $2,500. Okay. So that's one reason that people want to avoid probate is there's this fee you pay to the court. And in some states, that fee may be more. But in South Carolina, it's really not a super cost prohibitive fee. And I mean, if you had $1 million of probate assets, it very well may cost you more money to have a revocable trust and fund those assets into your revocable trust with, the help of an attorney as compared to the fee that you're avoiding. The bigger thing you're trying to avoid generally with getting outside the probate process is privacy, right? The probate process is a public process by which you provide the will to the court that's available really to anyone that wants to request a probate file from a court. So you can go look at, in South Carolina, if there's a famous South Carolina decedent that where they died in the county, you could, pay copy charges and maybe a fee and get their will and their documents that are public. You can locate those things. So getting those things outside of the purview of the public eye or the scrutiny of other parties can be very advantageous, especially in a situation where the plan maybe has more meat on the bones than just, hey, I leave everything to my spouse, I leave everything to my children equally. If we're treating people differently or there are other considerations, it can be very important to avoid probate in those contexts. So that's kind of the general gist of that.
And so, David, let's focus on what that process that many are trying to avoid, but let's focus on what the process actually is in the informal probate setting. We'll kind of limit it to that. So what are the major milestones that you hit throughout a probate process, and what deadlines does the personal representative have to keep in mind?
I would say as a general rule, most probate administration is going to take, in the state of South Carolina, it's probably going to take around a year, maybe a little less, but approximately a year. If you have an estate that is taxable from an estate tax perspective, which means it's a larger estate, maybe that timeline is longer, primarily due to the responsiveness of the Internal Revenue Service if you've got to file an estate tax return. But if it's a non-taxable from an estate tax perspective estate, I think you can generally kind of estimate about a year as a rough justice number. The timeline on that is when a decedent dies, under South Carolina law, whoever is in possession of the will is technically required to provide the will to the probate court in which the decedent resided. So my recollection is I believe it's 30 days. You have
correct.
30 days to do that. I will say, I think technically that statute is punishable by some sort of fee or something. I'm not sure it's ever been assessed that I'm aware of, but it is whoever has possession of a decedent's will is required to provide it to the probate court. From there, whoever may be named in the will as personal representative, and there are other people if they never seek to be appointed, but primarily the person named as personal representative would then apply and seek appointment if they need to administer assets. In addition, there's a separate application, but it's on the same form. You would apply for the probate of the will if you have not already done so. So the probate of the will is the admission of the will as valid. The appointment is seeking to be named as personal representative so that you can administer and settle claims and pay things or distribute assets ultimately. From there, once appointed, you have 30 days in an informal proceeding to provide notice. They call this information to heirs and devisees that you have been appointed. So for example, if I have a will that names my spouse as the beneficiary, but my 2 adult children are also alive, I generally, under South Carolina law, will have to give notice. My spouse will give notice to herself, even if she's named as personal representative, and she will give notice to the 2 adult children who, if I did not have a will that left everything to my spouse, they would be beneficiaries under my intestate estate if I died without a will. So there's a notice period that you provide that notice. From there, 90 days from appointment of the personal representative, the personal representative is required to file an inventory, which is essentially gives them time to locate, marshal, figure out what assets exist, and then they can list and provide values for those assets on the inventory. That is what the fee is based off of. So if you have probate assets that are listed on the inventory, you will pay the fee based on the amount that's listed.
And so, David, going back to your point earlier about one of the most important things being privacy, that's got to be a place where people really care about privacy, because not only can anyone go down to the court and see your will that you have filed, but they can also presumably pull up this inventory and see every asset that you owned.
Correct. So, I think the biggest place we see it a lot, and again, I think we have another podcast that talks about what are probate assets, which I would direct you to listen to if you have questions about what is probate, because not everything falls into this bucket. But one of the big ones that we see as planners is closely held business interests, right? So if I have a client that owns a successful closely held business and maybe they just own their stock in this business in their individual name, well, when they die, that may be probate asset. And theoretically, they may have to list, if the business is worth 10, 20, 30, however valuable the business is, they've got the personal representative may have to list that on the inventory. Well, one, that can be anti-competitive, right? If we've got to put a value out there that's public information for, the successors to the business. Two, in a case like that, depending on the structure, we maybe could have, in the context of probate fees, avoided substantial probate fees by funding those shares, which, depending on the nature of the business and other factors, may be easy to fund to a revocable trust or some other mechanism so that we're not paying probate fees. So you're correct, Jordan. Hard to value assets, things like that, businesses, substantial value, we generally want to be outside the probate process.
And so once we get through that deadline, we file the inventory, we pay our court costs. What do we then need to do in order to wrap up the estate? How do things play out from there?
In the state of South Carolina, when you seek to be appointed, the probate court works generally with a newspaper in their county that has general circulation, and they publish a creditor's claim. In the context, creditor's claim notice. The notice basically provides that, hey, if the decedent owed you money, you have a set amount of time to request and notify the personal representative and submit your claim to the probate court. And it's actually to the probate court that you have to submit that claim to. As a general rule, the claim is 8 months from when the notice is run. There are other outside limitations on it. If the decedent's been dead for over a year, there's a statutory bar on creditor's claims. So it's a little more complicated than that. But this creditor's claim period is generally what pushes estate administration to that year mark, right? Is because functionally, if I'm personal representative and the decedent has probate assets and I make a distribution to whoever the beneficiary is, whether it be me or other people, I can be personally liable to the extent the distribution or to the extent of a creditor's claim that I've distributed assets. So for example, let's say early, before the creditor's claim period expires, I distribute $100,000 of assets. And that's everything that the estate has. Well, then subsequently a claim comes in for $20,000. Well, I can be personally liable as personal representative for the $20,000 creditor's claim because I distributed assets early, which would have been available to satisfy this valid creditor's claim. So generally with us, we will advise clients that, hey, we should wait past the creditor's claim period when it closes, know what every claim that came in is, and then we can administer and settle this estate. In most cases, for a lot of the clients that we see, those claims may be pretty minimal, especially in a first death situation, as the client spouse is there and is generally managing and paying the invoices and bills and things that would have risen in the course of their life anyway.
And so, David, you get through the creditor's claims, and then is it just as simple as closing up the estate? What does that process look like?
So in South Carolina, you can generally waive accountings with the interested parties if everyone's in agreement. So for a lot of, simple estate administration where maybe it's a cohesive family unit and everyone gets along, you may be able to provide waivers of accountings and have a simplified process by which the personal representative just essentially affirms to the court and provides maybe documentation that supports they've done their job, but there's not a formal accounting process. There are, in other situations where people don't get along sufficient as well and we're not able to get waivers, you will have to potentially provide a formal accounting showing the distribution of assets, the payment of claims, payment of expenses, And you could submit that to the court. From there, if it's approved, the personal representative is discharged and we go on our way, basically.
And so, David, a goal of this podcast is, of course, giving individuals practical advice that they can take. And one thing, when I meet with clients on their estate planning, I always remind them that, hey, when you're thinking about probate and probate avoidance, you're not worried about you. You're going to be deceased at that point in time. You're worried about your successors in interest. You're worried about the person that you're naming as personal representative. You're worried about your kids and your beneficiaries and so on. And so when someone has passed away and an individual has been named as personal representative of the decedent's estate, and they're having to think, is this a role that I want to accept? Do I want to hire an attorney to help me with this? What is your advice to someone who's in that position when they've been named in that role and they're thinking of, can I do this? Is it smart for me to do this? Do I need an attorney to help me with this? What do you advise those types of individuals?
Well, I think the first thing they should focus and be aware of is that this is a fiduciary role, right? If you are named as a personal representative of someone's estate, you owe fiduciary duties, which generally means you've got to act, with impartiality and act in the best interest of the beneficiaries of this estate and actively work to preserve the estate for those people. And in my mind, one of the best things to show that you are trying to act as a fiduciary with the care and the intent to do what you've been tasked to do is to, probably enlist the help of someone that, has administered maybe not just one estate like your parents or your spouses, but probably has done dozens, if not even more, estate administration. So I think that's what I like to remind clients. Now, again, maybe there are simple estates that don't require the assistance of a lawyer. And I think if you go to probate courts, depending on the county in South Carolina, they can be fairly helpful. I will note that, outside the South Carolina context, Jordan and I are both licensed in North Carolina. And I would find that the North Carolina estate administration system is much more complex and requires much more documentation than the South Carolina, and primarily due to the fact that accountings can't be waived in North Carolina. So it ends up being a much more structured and formalistic process where you probably do want expert advice. That's generally how I would lay it out for clients. But honestly, the best way to help in estate administration is to hopefully have the decedent have met with a lawyer and have a solid estate plan and understand what the process looks like long before decedent passes away. Yeah. The worst estate administrations are ones where there's been no preparation or plan on the front end.
Sure. And I think that's all really good advice. And the other thing that I would note is that in addition to the personal representative wanting to protect themselves, make sure that they meet those fiduciary duties, a lot of times the personal representative is also a loved one of the decedent. Mm-hmm. And so one thing I always remind people of is, look, you're probably going through one of the hardest periods in your life. You've just lost a loved one. To the extent that you can get an attorney or someone else to help you through this process and take some of the burden off of you, I think that can be a very valuable help at that time and well worth the time and cost spent on it in many cases. David, I thought this was a great summary of a very complex topic. Thanks for joining me, and I look forward to talking with you about other topics in the future.
Sounds good. Thanks, Jordan.
Thanks for listening to TFE Talks. For more information, please visit our website at www.tfelawfirm.com. You can also follow us on LinkedIn, Facebook, and Instagram by clicking the links below in the show notes. If you have any questions about topics discussed in the episode, or you have recommendations for future topics, please email us at info@tfelawfirm.com. See you next time.